No facts were changed. No names, dates, numbers, or events were altered. No new information was added or removed. The flow, pacing, and emotional weight were strengthened while keeping the content intact. Marshals, stand down. Those 3 words changed everything. According to newly surfaced legal disclosures, the entire case against Judge Caldwell didn't slow. It didn't pause. It collapsed. No warnings, no second chances. The narrative we had been following for weeks disappeared in a single afternoon. JD Vance reportedly halted all proceedings after being confronted with what insiders are now calling the file. Documented evidence. Evidence suggesting the 114 allegations were part of a coordinated effort. And when you see what was inside those files, the timestamps, the metadata, the communications trail, it becomes clear why even the most vocal critics are reconsidering. Everything we thought we knew shifted.
So what pushed Vance to make such a dramatic reverse?
One moment, one decision, one set of files he should have seen weeks earlier. According to official filings dated within the last 72 hours, Vance was presented with evidence that fundamentally contradicted the foundation of the case. Not some of it, all of it. This wasn't random. This was months of accusations, media coverage, and coordinated pressure finally colliding with documented reality. The files trace back to communications as early as January of this year, internal memos, email threads with timestamps, and what legal analysts are calling one of the most significant metadata discoveries in a federal case this decade. Judge Caldwell, a man who spent months watching his reputation crumble in real time, was never meant to see these documents. Neither was the public. But someone made sure Vance did, and piece by piece, file by file, the house of cards collapsed. The moment everyone is talking about, the Marshals standing down, is coming.
But first you need to understand what happened to this man, and why the reversal isn't just dramatic, it's revealing. Here's what actually happened. The moment that made Vance pull the plug. March 15th, 2024. A secure briefing room inside the Justice Department. Vance arrived expecting a routine update. Instead, he was handed a 247-page dossier that had never been included in official proceeding. Inside were internal communications between 3 individuals central to the accusations against Judge Caldwell. Not rumors, not commentary. Time-stamped emails, text message log, recorded phone call transcripts, all obtained through legal discovery, all withheld during the initial investigation. One email dated January 8, 2024 reportedly read, "We need to accelerate the timeline. Caldwell's rulings are threatening the entire operation. If we don't move now, we lose our window." That's not vague. That's intent. That's coordination. And according to legal analysts, that's legally significant. But the files went further. They included a forensic analysis of the 114 allegations repeatedly cited in media coverage. That analysis revealed something startling. 47 allegations contain nearly identical language. Not similar, identical, word for word. A former forensic document examiner who testified in over 200 federal cases reviewed the metadata and stated, "This level of duplication doesn't happen organically. This suggests coordination. A template existed. Others followed it." The room reportedly went silent when Vance saw the creation date, November 12, 2023, 3 weeks before the first allegation was ever filed. The template came first. Let that sink in. But there was more. Communication logs showed coordination between certain accusers and members of a political action committee that had publicly called for Caldwell's removal months earlier. They referenced Phase 2. Media deployment windows.
According to the dossier, local news coverage spiked within 48 hours of coordination emails, a pattern. One legal strategist wrote, "Once the first 3 stories run, the narrative becomes self-sustaining. We don't need proof, we need volume, not truth." Judge Caldwell, a man with a 32-year judicial record, no prior complaints, and a reputation for constitutional originalism, wasn't targeted for what he did, but for what he might rule. And the final piece was a recorded phone call, February 22nd, 2024, between 2 primary accusers. One reportedly said, "It doesn't matter if it sticks legally. His career is over either way." That recording was buried. A subfolder labeled "Personal Notes," never disclosed. When Vance finished reviewing the materials, he asked one question: "Why am I just seeing this now?" No one answered. 47 minutes later, the order came down. Marshals, stand down.
If you're thinking finally someone is covering this with documents, subscribe, because what comes next is in the filing, but not in the headline. Not everyone believes the reversal. The accusers and their legal allies are calling it a political retreat. They argue the files were incomplete, selectively presented, possibly altered. A former federal prosecutor said, "You don't walk away from 114 claims because of new files. This looks like strategic withdrawal. If the evidence was so powerful, why wasn't it introduced through normal discovery?" Social media is divided. Some claim the setup narrative itself is another cover-up. A constitutional law professor noted, "The speed of this reversal is unusual. It raises serious questions." 3 accusers released statements standing by their claim. One said, "I know what I experienced. The system protected its own." Even analysts sympathetic to Caldwell admit gaps remain. 47 duplicates still leave 67 allegations unexamined. So what's the truth? Was Caldwell the target of a coordinated removal effort? The new evidence suggests that strongly. Or was the case dropped because the stakes became too high? The answer may live in the metadata, in the timestamps, in communications not yet released. What the documents show is coordination that predates the allegations themselves. That's not opinion, that's documented. And it didn't start here. Months earlier, Caldwell had been presiding over high-stakes regulatory cases. He blocked 3 major executive actions in 18 months. A senior correspondent said, "Every major policy fight is flowing through his courtroom, hero to some, target to others." Search traffic for Caldwell misconduct spiked before any allegations were public. The narrative was seeded early. Internal memos discussed contingency plans. If we can't remove him through legitimate channels, we create alternative pressure points. The stage was set. March 15th, 2024, 2:47 p.m. After 3 hours of review, Vance listened to the audio. 2 minutes, 17 seconds, silence. Then he said, "This case was built on something false. End it." Proceedings were suspended. Marshals stood down. Caldwell was cleared related to the initial filings. Within 6 hours, investigators opened an inquiry into the accusers. Subpoenas expected. The dynamic reversed. Legal scholars are calling this one of the most significant reversals in recent memory. Metadata suggesting allegations existed before incidents allegedly occurred points to potential fraud upon the court. The implications extend far beyond this case. If this tactic worked once, it could work again. Even attorneys who advocate for accusers admit the coordination forces hard questions. The emerging consensus is rare. Whatever you think of Caldwell, the process that targeted him was flawed, and that matters. 14 pending cases are now being re-examined. The investigation cost taxpayers $4.7 million. That money is gone, and if the allegations were manufactured, there may be no recovering it. Judges now know coordinated campaigns are possible. Some will stand firm, others may hesitate. That hesitation changes outcomes. Knowledge is protection. Watch sourcing. Watch metadata. Watch amplification pattern. If a story explodes in 48 hours, someone benefit. And that's what mainstream coverage isn't emphasizing. If it worked against a federal judge, the implications extend far beyond this case.